A warm welcome from the IUCN World Commission on Environmental Law, WCEL, to the 2020 WCEL Climate Justice Moot Court and the 6th Antonio Oposa Jr. Intergenerational Moot Court. My name is Christina Voigt. I'm a member of the steering committee of WCEL, and I am the chair of the Climate Change Specialist Group. The WCEL is one of the 6 volunteer expert commissions of the International Union for the Conservation of Nature, IUCN. The topic of the 2020 Moot Court could not have been more timely. The student teams prepared their memorials and their pleadings on the following question. What are states' obligations to protect forests in their national jurisdiction as a response to climate change and for the benefit of present and future generations? In a time where nature and forests are declining at an alarming pace, the answer to this question is of crucial importance. Forests are an important part of the solution to climate change, and they provide biological diversity as well as the home to many peoples, indigenous and local communities. The student teams elaborated which current and intertemporal obligations of states exist that also our children and future generations will enjoy the beauty of this ecosystem and its important ecological functions. WCEL is most grateful to David Foreman, the director of the Environmental Law Program at the William S. Richardson School of Law at the University of Hawaii at Manoa, for his tireless organization and proceedings of this moot court. WCEL is also grateful to the organizing committee, which consisted of Justice Antonio Benjamin, Professor Nicholas Robinson, Professor Rose Lisa Eisma Osorio, Professor Jose Rubens Morato Leite, Professor Agne Michelot, Professor Emily Gaia, and Professor Nick Briner, as well as the members of the Early Career Group and the Climate Change Specialist Group of the WCEL, as well as Emily Gaskin, the Executive Officer of WCEL. We thank them all for their careful preparations of the moot court, as well as for coaching the student teams. And we would, of course, want to thank and congratulate the excellent and truly global teams of students. They came from 6 universities from all over the world. We had one team from the University of La Rochelle in France, one from the University of Oslo in Norway, one from Strathmore University in Nairobi in Kenya, one team from the Federal University of Santa Catarina in Brazil, one from the University of Cebu in the Philippines, and one team from Victoria University in Wellington, New Zealand. Their work and their dedication and their legal scrutiny will be showcased in this video. But all this would have been impossible without the members of the court who were hearing the student pleadings and examined the students, our judges. We are deeply honored and very grateful for the dedication of time and energy by Justice Millicent Odiney from the High Court of Kenya, by Associate Justice Robert Torres from the Supreme Court of Guam, by Justice Nicola Payne from the Land and Environment Court in New South Wales in Australia, by Justice Michelle Weeks from the High Court of Barbados, and Justice Michael Wilson from the Hawaii Supreme Court in the United States. Finally, we thank Kinetic Productions for providing us with this video format. And now we would like to invite you all to enjoy and to listen and learn from the 2020 WCEL Climate Justice Moot Court and the 6th Antonio Oposa Jr. Intergenerational Moot Court.
Good day, everyone. In behalf of the IUCN Academy of Environmental Law, I would like to take this opportunity to congratulate the World Commission on Environmental Law and the organizers of this extraordinary event, the World Moot Court, on the question of the responsibility of states under international law to protect forests as a response to climate change. It is indeed such a pleasure to see a collaboration of law students, law professors, and academic institutions all over the world in dealing with such an important question in international environmental law. This moot court is an example of the role of environmental law in finding solutions on the many challenges, particularly climate change and unsustainable development that our planet is facing right now. This moot court is also a great example of collaboration between two institutions, the IUCN Academy of Environmental Law and the World Commission on Environmental Law, which started during the World Conservation Congress in Hawaii and continued on in past colloquia of the Academy of Environmental Law. The Academy, as an organization of more than 200 member institutions, focuses on strengthening environmental law teaching and research. And we understand the critical role of moot courts in environmental law education, as this help usher in future generations of lawyers and researchers all over the world who seek to protect our planet for the benefit of present and future generations. Once again, my warmest congratulations to everyone. Mabuhay.
Dear colleagues, hello to everybody. I'm very pleased to meet you through this video. I'm Émilie Gaillard, Professor of Private Law at Sciences Po Rennes and the General Coordinator of the Normandy Chair for Peace, which has been created during the Second World Peace Forum here in Normandy in order to change the narrative and make peace with the earth. We have the great honor to count on Professor Nicholas Robinson as Chair Emeritus and also on Tony Oposa as the leader, inspiring and guiding all the teams, which are all working around more than 11 lines of different research lines, which are dedicated to peace with the earth, indigenous people, sanctuarization of forests, education on peace with nature, on right for future generations and how to represent and defend future generations, on the rights of nature, and many other topics such as the one of legal indicators under the leadership of Professor Michel Prieur. I would like to welcome all of you and to congratulate all the colleagues and more specifically Professor David Foreman, who had a leadership on the organization of the several moot courts, Tony Oposa Intergenerational Moot Courts. I would like to warmly thank him also for involving me to this great experience and all the students. You will see how rich the moots were and how inspiring the topics were. I wish you a very, very good day and see you soon.
Christina Voigt, Liza Osorio, and Emily Gaillard were all involved in the very first Intergenerational Moot Court and many of its subsequent iterations. Without their continued support, this Intergenerational Moot would be nowhere near as successful. The World Commission on Environmental Law hosted the first, third, and sixth moots, which initially took place in Honolulu, then Brasilia, and this year virtually, all thanks to the enthusiastic leadership of outgoing WCEL Chair Antonio Benjamin. The IUCN Academy of Environmental Law hosted the second and fifth moots in Cebu and Kuala Lumpur, and the Normandy Chair for Peace hosted our fourth moot in Caen. I'm proud to be an active member of all three organizations. You are all invited to view written memorials and video from previous intergenerational moot courts on the Environmental Law Program website under the IUCN tab. That's at blog.hawaii.edu/ELP. The origins of this unique moot trace back to what Philippine environmental attorney Tony Oposa called a play shop on the North Shore of Oahu in 2015. Kuya Tony brought together experts from academic and diplomatic fields, along with advocates from non-governmental organizations around the globe, to brainstorm new ways of addressing our climate and biodiversity crises. Rather than typical moot court competitions, this intergenerational moot is intended as a proof of concept, with the ultimate goal of advancing arguments that we hope practitioners will be able to eventually use before the International Court of Justice. This unique collaborative effort includes contributions from expert commentators. These individuals donated their times to review the students' draft memorials and provide helpful feedback to improve the final submissions. In addition to stressing geographical and gender diversity, the intergenerational moot seeks to highlight a variety of themes that we hope will be of use to those who practice international environmental law. The moot is also a showcase for early career youth, typically including the added benefit of networking opportunities and participation in international conferences to increase the students' substantive knowledge and exposure. This year, however, the COVID pandemic forced us, like many others, to be innovative and resilient. WCEL Executive Officer Emily Gaskin's logistical support across multiple time zones was invaluable. Drawing from more than 4 hours of video recording across 3 separate days, we are pleased to provide you with highlights from the oral arguments. Thanks to WCEL funding, we were able to retain the services of Kinetic Productions, which previously donated its equipment, staff time, and expertise to our event in Honolulu. Congratulations and sincere thanks to all the students, coaches, judges, and everyone else who contributed to this effort. Aloha.
Welcome to this mock session of the International Court of Justice. My name is Justice Robert Torres, and I'll be serving as co-president of the court, along with Justice Millicent Odene. We are joined by fellow justices Nicola Payne, Michelle Weeks, and Michael Wilson. Before inviting my esteemed colleagues to ask a few questions, we'd like the parties to make their oral submissions, starting with one of the agents from the Philippines, representing the Association of Southeast Asian Nations. You may proceed.
It is our submission that there is a need for immediate judicial intervention from the International Court of Justice, as there have been numerous political failures on climate crisis. Combating climate change requires collective action on both national and international and on many fronts. Some democratic countries which face strong individualist traditions along with lack of trust in government face a conundrum of difficulties in devising solutions to the climate challenge and protection of forests. As such, we reiterate the need for judicial intervention and the importance of obtaining advisory opinion in defining states' obligation more clearly. In proceeding with our submission, we would like this court to take cognizance of the fact that the climate of small island state is influenced by large ocean atmosphere interactions, and coming from a coastal state myself, I can attest that our people's way of life is largely dependent on the ocean. We fear that the ocean that gives us life now might one day take everything away, because impacts of climate change have the potential to make coastal states and small island states such as Kiribati, Tuvalu, and Maldives uninhabitable. If societies or even communities are forced to leave because of these climate change impacts, some nations may lose their sovereignty. We may lose our sovereignty. Your Excellencies, this is why for our first submission, we would like to point out that the UNFCCC aims to achieve stabilization of greenhouse gas concentrations in the atmosphere and to enable economic development to proceed in a sustainable manner. In this connection, specifically stated in Article 4D of the UNFCCC and Article 5, Paragraph 1 of the Paris Agreement, states have the responsibility to promote sustainable management, conservation, enhancements of sinks of greenhouse gases to address the climate crisis. As defined, a sink is any process, activity, or mechanism which removes a greenhouse gas or a precursor of a greenhouse gas from the atmosphere. Forests are great examples of carbon sinks as they store 14% of annual carbon dioxide emissions. Pertinently, the most popular form of sink enhancement is growing more trees and limiting deforestation, and yet 3.0 billion tons of carbon dioxide a year is caused by tropical deforestation for products like palm oil, soybeans, and beef. Together, they have an outsized impact on the health of our world's forest and climate, annually contributing 3.83 million hectares of deforestation, an area about the size of Switzerland. However, we are not saying that economic development must be hampered in the quest to find ecological justice. There is a way to balance both. This is through sustainable development. As Judge Rimantri aptly said in the Gabchikova case, development can only be prosecuted in harmony with a reasonable demands of environmental protection. Your Excellencies, change is possible. There are strategies to produce these products that allow the world's forests to thrive. For example, the beef moratorium in Brazil has led to important changes in the actions of ranchers, and it is one of the most important reasons why Amazon deforestation in Brazil dropped by 70% from 2005 to 2014. Although recent fires from the Amazon shows there is still much work yet to be done. In addition to this, I would like to point out that AOSIS has been doing their share of the work in trying to mitigate the effects of climate change through protection of ocean and coastal ecosystems that serve as blue carbon sinks. Small island states' adaptive capacity is often limited by insufficient technical and institutional capacity, as well by lack of funds. The cost of many adaptation measures, especially hard engineering measures, is frequently beyond the means of small island states' national government. Even when such projects can be financed internationally, it can be at risk of diverting development aid from other priorities. It has been said, Your Excellencies, that you can engineer your way out of anything. And I suppose it's true. If you had enough money, you could raise or rebuild every street and building in a rich city by 10 feet, and the city would be in a pretty good shape for the next century or so. Your Excellencies, one of the hard truths about sea level rise is that rich cities and nations can afford to build seawalls, upgrade sewage systems, and elevate critical infrastructure. Poor cities and many small island states cannot. And as water rise, millions of these people from poor cities and small island states will be displaced, many of them in poor countries, creating generations of climate refugees. Thus, to prevent this, I will recap that first, states have the obligation to promote, conserve, and enhance forests under the UNFCCC. And second, states have common but differentiated responsibilities to adapt to climate change.
This submission shall proceed under two main heads of argument. The first is the obligation of states under international law, where I shall discuss state obligation under customary international law and environmental principles. The second argument I shall submit before the court is the balancing of development with the right to a healthy environment. Here I will discuss how courts have been able to achieve this, specifically in the cases of SER versus Nigeria and ANW versus the Attorney General of Tanzania. Moving to my first argument, obligation of states under international law, specifically under customary international law. Customary international law results from a general and consistent practice of states that they follow from a sense of legal obligation. The African Union submits the following customary laws for the court's consideration. The first, prohibition against transboundary environmental harm. The core of this responsibility is that states may not conduct or permit activities within their territories without regard to other states or for the protection of the global environment. Thus, a state must refrain from any activities that may harm neighboring states or the global environment. The second that we submit before the court is standard of care. In relation to the prohibition of transboundary environmental harm, the question of standard of care arises. Two general approaches have emerged on this issue. The first approach is that states are generally obliged to achieve actual prevention of harm. The other approach is that states are under an obligation to act with due care in implementing measures of prevention. The third customary international law we submit is the principle of sovereignty. The obligation not to cause harm to the environment of other states or to the areas beyond national jurisdiction cannot be understood separately from the notion of state sovereignty. The core of this principle is that all states are sovereign and are not subject to any other determination but their own. Therefore, as states have sovereignty over their territories, they have an obligation to ensure that their activities do not harm their neighbors or the global community. Additionally, they have a duty of care to prevent harm to their neighbors and to the global community. I will now move to environmental principles. The African Union submits the following principles for the court's determination. The first, the principle of cooperation. According to Principle 7 of the Rio Declaration, states shall cooperate in a spirit of global partnership to conserve, protect, and restore the environment and integrity of the Earth's ecosystem. In view of the different contributions to the global environmental degradation, states have common but differentiated responsibilities. A good way in which states have achieved this is through multilateral environmental agreements such as the United Nations Framework Convention on Climate Change. The ultimate objective of the convention is to stabilize greenhouse concentrations at a level that would prevent dangerous human-induced interference with the climate system. I will now move to the second principle, which is the precautionary principle. The Rio Declaration provides that in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. The third principle we submit before the court is the principle of prevention. The preventative approach seeks to avoid harm irrespective of whether or not there is transboundary impact or international responsibility. The African Union submits these customary laws and principles for the court's consideration. In the view of the African Union, these laws and principles highlight the importance of environmental conservation, which not only benefits the present generation, but that of future generations. Additionally, they highlight the duty that each state has internationally to maintain a healthy environment by combating climate change. They also highlight the right to a healthy environment as enshrined in Article 12 of the International Convention on Economic, Social, and Cultural Rights, as well as Article 24 of the African Charter. Therefore, they are of importance to the court. I will now move to my second argument, which is balancing development with the right to a healthy environment. Under the African Charter, African states are required to ensure that all peoples have a right to a general, satisfactory environment favorable to their development. To this end, the African Union submits these cases as instances where courts have balanced the right to a healthy environment with development. The first case is Serap versus Nigeria. For decades, the Niger Delta region has suffered from oil spills, which destroy the area and deny the people living there adequate access to clean water, food, and a healthy environment. The applicants allege that these spillages led to a violation of the right to a healthy and adequate standard of living. In its consideration of the case, one of the main questions the court had to answer was whether Nigeria had violated the right to a satisfactory environment provided in Article 24 of the African Charter. The court declared that Article 24 requires every state to take every measure to maintain the quality of the environment. The court found that the Nigerian government had failed to protect the Niger Delta and its people. The court therefore ordered Nigeria to take all effective measures to ensure restoration of the environment of the Niger Delta. With this decision, the court recognized the right to a healthy environment as provided for by the African Charter. The second case I shall submit before the court is ANW versus the Attorney General of Tanzania. In 2010, Tanzania released plans to build a 53-kilometer road across the Serengeti National Park. The applicants claimed that the construction of the road would have had a negative impact on the environment, animal behavior, and the quality of life of the citizens. The applicants argued that Tanzania had violated its obligation in respect of the Serengeti, which had been declared a World Heritage Property of outstanding value. The court held that partner states must respect their environmental obligations. In summary, the African Union asks the court to consider the international law highlighted in this submission. The African Union also asked the court to recognize that in order to secure a healthy environment for current and future generations, the threat of climate change must be addressed. However, a balance must also be struck between development and the right to a healthy environment. Thank you.
Good day, my name is Camille, and I'm the oralist representing UNICEF alongside my teammate Roberto, who is also here today. We will plead today on behalf of children's rights and human rights in the context of the environmental crisis. Our pleading will be subdivided into three main parts. We will start off with a brief reminder as to why it is important for states to protect forests. Secondly, we will emphasize the obligations of states under current international treaty law in defense of forest, where we will mainly focus on the Paris Agreement. And we will lastly be addressing the obligations of states to protect human rights and children's rights in light of the climate crisis. So we wish to start off this pleading with a quote by Peter Bolenbun, who wrote a book entitled The Secret Life of Trees. And he said, if we want to use forests as a weapon in the fight against climate change, then we must allow them to grow old. But why it is important to protect forests to let them grow old? Well, climate change is caused by anthropogenic activities, which lead to a scarcity of natural resources and ongoing deforestation. Since the New York Declaration on Forests inauguration in 2014, tropical primary forest loss has accelerated by 44% compared to the baseline of 2002 and 2013. The anthropogenic pressures on biodiversity have sharply increased since the 1970s, with 1 million species estimated threatened with extinction. Extreme weather events have displaced a record of 7 million people in 2019 alone. Deforestation caused by human activities is hindering the tropical forest's ability to absorb carbon dioxide from greenhouse gas emissions, with the Amazon rainforest at risk of becoming a carbon source within only 15 years. Reducing deforestation and increasing forest restoration is essential to meet the temperature goals of the Paris Agreement. Forests represent one of the largest and most cost-effective climate solutions thanks to their ways of sequestering carbon, yet an average of 13 million hectares of forest disappear each year, often with devastating impacts on indigenous communities and children. Now, on to our next section. What are exactly the obligations of states under current international environmental law in defense of forests? We here decided to focus on the Paris Agreement, as it is the most recent legally binding international treaty encompassing both human rights protection and forest preservation. The agreement reserves a special place for forests, as Article 5.1 of the agreement states, and I quote, "Parties should take action to conserve and enhance as appropriate sinks and reservoirs of greenhouse gases, including forests." This article ties into the general obligations of parties to keep temperatures between 1.5 and 2 degrees Celsius, according to the Article 2.1a of the agreement, which describes these temperature goals. Parties to the Paris Agreement also have the obligation to put forward NDCs at their highest possible level of ambition, as read in Article 4.1 and 4.3 of the agreement. Article 4.1 states, and I quote, "In order to achieve the long-term temperature goal, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, so as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases." This wordy provision urges the parties to rapidly reduce their greenhouse gas emissions as soon as possible, consequently creating a new international objective to keep under the long-term temperature goal of 2 degrees. After acknowledging that climate change is a common concern of humankind, the preamble to the same agreement states that parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights, the right to health, the rights of indigenous people, of children, and the right to development. In the preamble, many references to human rights and environmental obligations are made. And this agreement, including the preamble, are legally binding and puts forward legally binding goals, and it is of little significance that only the preamble refers to existing human rights obligations, as parties have also entered into other human rights treaties which already protect them. In an important sense, the Paris Agreement signifies the legal recognition by the international community that climate change poses unacceptable threats to the full enjoyment of human rights. States have obligations under international environmental law to combat deforestation and protect forests in order to fulfill their human rights obligations to present and future generations.
My name is Sophie Ross, and it is my pleasure to present Aotearoa New Zealand's submission relating to international trade law and the protection of forests. This submission will briefly discuss how international trade law relates to forests before considering some of the current international instruments at the intersection of forest protection and trade. Aotearoa New Zealand recognises the challenges of addressing these issues raised and respects the international trade system as important for our own state's prosperity, as well as that of the international system. However, it is also undeniable that maintaining the status quo is not an option in the face of climate change, should we seek to preserve a reasonable standard of life for present and future generations. This submission requests that the court make declarations recognising the need to shift away from prioritising trade at the expense of forest ecosystems, as the current unbalanced approach is both contributing to climate change as well as hindering effective climate action. Forests include a huge variety of species and are involved in a number of natural processes, such as that of water, soil, and climate. However, natural resources derived from forests, particularly timber products, are typically required at the very start of global supply chains and are therefore crucial for international trade as it currently functions. Therefore, the current focus of international trade law that regulates forests is designed to ensure the ongoing presence of forest species for trade. Because of this, states focus on the regulation of particular forest species which are used in trade. And while this means the resource itself is available for exploitation in the future, it can and has in fact led to the degradation of wider forest ecosystems. This is further exacerbated by the wide variety of different actors that have vested interests in forests as a resource for trade. Various private actors are involved throughout the process of forest exploitation, from forestry to production, export, and investment. These actors will seek to utilise domestic and international trade law to maximise their capacity to exploit forest resources. This may ultimately undermine higher-level international environmental instruments that have not been implemented strongly in domestic law. Current views about state sovereignty over natural resources can also be a challenge to effectively coordinating forest protection in the light of trade. This is because it is considered to be within a state's right to exploit their natural resources for the benefit of their state interests. However, we now know that the Earth's natural ecosystems are not divided easily along state lines, and climate change in particular is increasingly making it clear that what one state does to its forests does affect others. Because of this, New Zealand submits that international law needs to recognise forests and forestry as a matter of international interest. International trade fails particularly where it neglects to appreciate the interdependence of environmental protection, ecosystems, and human well-being. When we consider some of the major international instruments that manage forests as a matter of trade, it is evident that trade is seen as a priority, while the health of forest ecosystems is not sufficiently accounted for when considering the demands and pressures of climate change. This is discussed in our written submissions regarding the International Tropical Timber Agreement and the Convention on the International Trade in Endangered Species. The International Tropical Timber Agreement creates obligations in relation to trade as well as sustainable forest management. However, it is still largely a tool to facilitate trade. Under the Article 1 objectives, it refers first to the expansion and diversification of international trade in tropical timber, and only secondarily qualifies this as being from sustainably managed and legally harvested forests. In another way, the Convention on International Trade in Endangered Species operates on a negative list approach, in which it only protects species which are specifically included within its appendices. Forests are composed of hundreds of species, and further, as they are complex and interdependent ecosystems, it is important to ensure the overall health of the forest, rather than an inconsistent protection of different species within it. This is arguably very concerning, particularly when new species have struggled to be added to the Convention's appendices. The Convention is also still fundamentally an instrument for trade, and this is reflected in the fact that the GATT Secretariat was consulted in its development. This, combined with its negative list structure, means that it is an instrument that attempts to walk the tightrope of sustained exploitation of natural resources, as opposed to actively pursuing sustained ecosystems. Both of these are examples which interplay with the concerns around the fragmentation of international law in this area. There are not clear obligations to protect the environment, nor forests in particular, yet there are clear obligations and opportunities for trade to both facilitate and actively encourage the exploitations of forests for trade purposes. Our written submission also explores trade law in the context of the World Trade Organization. It was particularly noted that states are not required to, under the WTO, to exploit forests, but where they choose to do so, they must be aware of WTO obligations, such as making resources available in trade for other WTO members. It is clear that encouraging and facilitating trade has been a priority of states and of international organizations, particularly since the end of the Second World War. However, it must also be accepted that as it currently functions, this is interfering with effective climate action. Because of this, looking at obligations under international trade is a useful exercise, as it highlights where environmental protection efforts are undermined by other areas of law. Based on our submissions, we respectively request that the court makes the following declarations. Firstly, we request the court declares the need for environmental protection to be a primary consideration and a key priority of states across all areas of international law, and particularly in the context of international trade. This shift reflects the increasing knowledge about the state of the world's environment, and particularly the unprecedented nature and urgency of climate change. Secondly, we request the court recommends that international instruments, such as the CITES and ITTA agreements, move away from a compartmentalized or negative list approach, which identifies certain specific species. They need instead to adopt an ecosystem approach that better supports the well-being of wider ecosystems that these species are naturally a part of. Thirdly, and finally, we request that the court declares that where there is ambiguity around states' obligations in relation to natural resources and the environment, there should be a presumption in favor of the approach that best protects the environment. In the context of this discussion in particular, it should be that international trade law is considered in light of international environmental law, rather than the reverse, which has arguably been the case in historical practice.
For a long time, France has played an important role on the international scene and protects many rights, including those of future generations, by adopting a policy that is increasingly protective of the environment and the human condition. However, due to the intensive overexploitation of natural resources that we have pursued, we have largely contributed to global warming, and this climate change is now affecting our country very closely. Indeed, France has many territories around the world, such as Guadeloupe, French Polynesia, or Réunion Island. And as climate change causes changes in forest ecosystems, France can observe this phenomenon all around the world. And the fact that these ecosystems are in danger is an alarming observation insofar as forests respond to ecological imperatives by contributing to the storage and development of carbon sinks that help regulate climate change. However, the fight against this phenomenon cannot be conducted on a small scale, and international law responded to this in 1972 in the Stockholm Declaration on the Environment by saying that international matters concerning the protection and improvement of the environment should be handled in a cooperative spirit by all countries, big and small, on an equal footing for the benefit of present and future generations. This principle was reiterated in the Rio Convention in 1992, which was the first to take forests into consideration. Indeed, in this convention, state parties, including France, have committed to protecting and restoring biodiversity, which is essential for the protection of the rights of present and future generations. It is with this goal in mind that the forests were protected, because they are a means of protecting biodiversity as they are the best host for it. This protection of forests is therefore done implicitly, insofar as the only explicit obligation here is to protect biodiversity. But on the other hand, the international obligation to protect forests has nevertheless tried to be implemented in 1994 through the United Nations Convention to Combat Desertification, which is the sole legally binding international agreement linking environment and development to sustainable land management. However, the difficulty is that states remain sovereign over the natural resources, and despite this international agreement of 1994, the international obligation to protect forests is far from being explicit and is rather deduced from the international obligation to protect biodiversity or the environment in general.
The usefulness and the possibility of adopting an ecological approach to international environmental law, which we recognize as unprecedented in the history of this court. However, as the current environmental, health, and economic crises have demonstrated, classic environmental law rules and approaches have been somewhat ineffective in curbing environmental degradation and managing complex, cross-sectoral environmental problems. Among those issues, we can highlight forest fires, deforestation, species extinction, and their long-lasting impacts on society and nature. Moreover, these environmental laws and rules have largely failed their purpose of guaranteeing social ecological integrity and respecting planetary boundaries. Within the scenario, revisiting and rediscussing the very own international environmental law fundaments and frameworks, and moving away from a reactive and anthropocentric type of behavior become an imperative in the 21st century. In ecological law, nature's intrinsic rights can be fully recognized, resulting in a duty for policymakers and decision makers to act to protect the environment. I'm not arguing here that this does not come with significant challenges, but these challenges will have to be addressed appropriately by 21st century courts. As outlined in our written statement, we do not need more conventions and treaties. Instead, we have to start discussing more proactively from an ecological law perspective, new forms of legal representation, the nature and extent of existing legal obligations, the content and scope of existing legal principles, the concepts of non-regression, inter and intergenerational equity, interspecies equity, and I even dare to say, Your Excellencies, rights of nature. In general, we argue that applying an ecological approach to international legal frameworks for forests will help us better understand and specify the causation of environmental damages and the extent of legal obligations, which should consider the nature's right to exist, to thrive, and evolve.
We have the imposition of liability on the state deemed responsible for causing a given problem. However, these regular obligations will not be sufficient for transboundary environmental harms and the protection of forests in the context of climate change. Therefore, I will briefly discuss state obligations regarding transboundary harms under international law, and I will also argue that courts and practitioners must interpret these obligations from an ecological approach. The fundamental international law rule applicable to transboundary environmental harms is the non-harm rule, which means that states may not conduct or permit activities in their territories, or what is even more important to highlight, common spaces without consideration to other states or the protection of the global environment. This rule encompasses two other international law principles: the state sovereignty principle, more specifically the permanent sovereignty over natural resources principle, and the principle of territorial integrity. The first one will be limited by the second, and by the fact that state sovereignty cannot mean that states will be free to exploit all their natural resources and destroy the natural environment within their territories. These two principles together, as said, give us the non-harm rule. A series of thematic specific international documents comprise this notion, as it is the case of the Stockholm Declaration on its 21st principle, the UN Convention on the Law of the Sea, and the Ozone Layer Protection Convention. Nevertheless, beside the compensation for the damages already incurred, the non-harm rule also comprises the duty to prevent environmental damage or the duty of environmental protection. For the sake of time, we will not delve into the specifics of each case law mentioned in the memorial, but it is already recognized that by the obligation of not to cause harm to other states, states must prevent the occurrence of transboundary harms. This duty is fulfilled by acting with due care in the implementation of preventive measures or acting with due diligence, meaning that states shall take all the appropriate measures to prevent significant cross-border damages or to reduce their risks. Hence, states have legal obligation even before the occurrence of any harm. The opening to the discussion of this preventive dimension of the non-harm rule was provided by cases such as the Trail Smelter case and the pulp mills case. However, specifically in the case of transboundary environmental harms linked to climate change, other complex issues must be taken into account. One may verify climate-related harms by demonstrating that certain human activity or certain subject would not have taken satisfactory preventive measures or would not have fulfilled their obligation to reduce their greenhouse gases emissions and therefore would have contributed to the harmful result. Hence, in this case, the causal relationship may be identified using evidence-based knowledge about climate science, in the sense that climate science already provides us precise information about human activities that contribute to increasing climate change. This takes us back to the obligation of prevention, as by conducting these harmful activities, states will have already breached their obligations to cut their GHG emissions, as previously said by Elisa. In brief, changes in the climate affect forests and ecological process, and forest degradation affects climate regime. In such a complex scenario, one faces the challenge of interpreting the chain of causality, and to do so entails a broader and more comprehensive approach. In this sense, if it is not possible to claim that the harm caused by a particular state caused the climate change, this state shall be held responsible for contributing to the increase of climate change. Beyond these obligations, we propose a more integrative, complex, and systematic perspective to interpreting these duties through the ecological law lenses. Taking the specifics of environmental damages into account and the proposed ecological approach, the first principle that we believe should guide the interpretation of the non-harm rule is the indubio pro natura principle, which has been developed and incorporated by several Latin American countries. This principle calls for the adoption of a preventive approach as it goes hand in hand with the precautionary principle. Hence, the indubio pro natura has been an interesting contribution to the analysis of the state's obligation regarding transboundary environmental harms and the case of identifying the causal chain of climate-related harms. Regarding the intangible dimensions of environmental harms and state's obligation under international law, we would like to call attention to the interests of forest dwellers, indigenous peoples, and local communities. An ecological approach to transboundary environmental harms may lead us to conclude that damages to the environment, including climate-related ones, can result in negative impacts on a broad spectrum of existential, cultural, spiritual, and intergenerational dimensions of IPLC's rights, which are subject of states' obligation under international law. Lastly, in light of the specifics of environmental damages and the intangible dimensions of these damages, practitioners and courts shall consider the evaluation of ecosystem services, as it is an essential element of an ecological law perspective and a fundamental argument towards the preventative dimension of the obligation of not to cause transboundary environmental harms. Hence, in the case of environmental harms, one may take into consideration the impacts of ecosystem services, specifically those provided by forests, and therefore the notion of integral repair. So, Your Excellencies, in conclusion, our reading statement provides a set of guiding questions and supporting materials that reflect all of these arguments and might help the court navigate the complex questions discussed in this request for an advisory opinion. Our position is that an ecological approach to environmental law, the multilateral environmental agreements, and soft law instruments mentioned previously call for a positive duty to protect forests, especially in the face of climate change.
Legal personality for nature is a tool that states can use to better protect forests at a national level. Recognizing nature as a legal person can also better recognize people's legal responsibilities to protect nature and act as its guardians. These tools can implement our responsibilities under the fundamental legal principles of environmental quality and protection, through better reflecting alternative worldviews of our relationship with nature, such as those held by Indigenous peoples. They can also better uphold Indigenous human rights laws, such as those addressed by our learned friends to agents from Ecoforestania. This option of legal personhood can be seen to be becoming more commonly used across the world in Aotearoa, New Zealand, India, Ecuador, and Bangladesh. The Colombian Supreme Court used legal personality with regards to the Amazon rainforest. This gives more protection to the forest and acknowledges indigenous views. The forest is treated as a subject of rights, entitling it to be protected, conserved, maintained, and restored. The state of Colombia is responsible for this. The Colombian Supreme Court based its decision on fundamental responsibilities of states of environmental protection and human rights laws. I note that the Colombian Supreme Court considers itself guided by hard and soft law, international law, not just its own national law, and that this decision was not an isolated one, but rather reflects international trends. This decision flowed on from the earlier Atrato River decision that held the river to have legal rights and that humans had responsibilities to look after it. That case was an important illustration of the court utilizing grand narratives about environmental protection. For another example, New Zealand has given legal personality to both rivers and forests in order to promote Indigenous rights of Māori iwi. The Te Urewera Forest was given legal personality in 2014 through negotiations between the Crown and Tūhoe, who are the iwi who claim the forest, which resulted in the title being vested in Te Urewera itself instead of the government. Courts in India and Bangladesh have also declared legal personality to rivers. There are enough countries following this conception to establish that there is an emerging international custom that could exist one day to be binding over countries that have recognized this custom. The states that have given legal personality to aspects of nature have been considering the actions of other states who have done so and justifying their adoption of the same tools by reference to these other practices. Thus, while states are not yet feeling totally bound by this emerging custom, they are acknowledging that it is a viable and possible option. When legal personhood becomes an international principle or customary international law, then all countries will have to consider the rights of nature and human responsibility in their decision making. It'll make deforestation a much larger legal problem, because if a forest owns itself and has a regulatory body maintaining and representing its interests, then cutting down much of the forest would be a breach of a lot of legal rights. We submit that legal personality would be an extremely useful tool for the court to adopt in order to better protect the world's forests. We also believe that Earth jurisprudence would be a brilliant way to tackle this from a different perspective, as it's becoming increasingly acknowledged and would be taking it a step further than legal personality.
During one of the anniversaries of the United Nations, the IOSIS reiterated its urgent call for economic support and climate action in dealing with the double financial blow brought by the pandemic and the ongoing fight against climate change. Here, Belize UN Ambassador Lois Young emphasized that these vulnerable island states are in a state of economic emergency. The IOSIS are sinking, not just from climate-induced sea level rise and other impacts. They are sinking in debts. Our economies, the IOSIS, are resource-based, and with the destruction brought by disasters, such as the tropical cyclone that hit the Solomon Islands, Vanuatu, Fiji, and Tonga, and Hurricane Nana in Belize, the fiscal space and resources in our countries are becoming limited. While we are facing 21st century storms, stronger and more destructive due to climate change, our disaster response systems, particularly the role of loss and damage in addressing climate impacts, need to be revisited. In the domestic level, there is an emerging trend of bringing carbon majors and the government itself before the courts, such as in the case of the Philippines, in Greenpeace versus Exxon, where 12,058 Filipinos brought before the Commission on Human Rights to investigate the responsibility of carbon majors like ExxonMobil, Chevron, and Shell, and in Leluya versus RWE, where petitioners Leluya asked the German court for compensation, arguing that RWE's emissions have worsened the melting of ice caps, posing actual risk. And in another aspect, we have citizens, and these citizens have been vigilant in holding states responsible for their environmental obligations, such as in the case of Urgenda versus Netherlands. Now, it is high time for this court to amplify the state's obligations in loss and damage caused by climate change. Your Excellencies, even if we completely reduced or stopped emitting greenhouse gases, the effects of past emissions are still unavoidable. Some climate events are beyond the ambits of mitigation and adaptation, such as extreme events in the form of flood, storm surges, and drought. And we have slow onset disasters, such as the loss of biodiversity, sea level rise, and rising temperature. This is where the Warsaw International Mechanism comes into effect. In Warsaw, parties agreed to promote the implementation of approaches in addressing loss and damage, particularly paragraph 14, wherein it requests developed countries to provide vulnerable developing countries finance, technology, and capacity building to address loss and damage. Similarly, the EOSIS are entitled to compensation based on the draft article on the allocation of loss in the case of transboundary harm. It is a well-recognized principle that states should refrain from inflicting damage on or violating the rights of other states. In invoking this principle, there must be at least significant damage that has occurred and that the severity entails serious consequences. Evidently, there are data showing the contributions of states to pollutants responsible for climate changes, and this is available from the Intergovernmental Panel on Climate Change reports and the state inventories themselves. From here, it can be seen that the causal link had been established by scientific evidence. Your Excellencies, there has been a unanimous acceptance that climate change is real, there is actual harm, and the EOSIS are at the receiving end. Small island developing states account for less than 1% of the world's greenhouse gases, but we suffer greatly. Take, for example, the case of Vanuatu. Between 1969 and 2010, it has seen an average of 2 to 3 cyclones per season, and in 2015, Cyclone Pam managed to displace 75,000 peoples. The world has seen an annual and seasonal increase of temperature at a rate of 0.14 degrees Celsius per decade since 1948. With 1/3 of our population living on land that is less than 5 meters below sea level, the threat of sea level rise, storm surges, and coastal destruction pose existential risk on our part. 80% of our population derive our livelihoods from weather-sensitive industries, tourism, agriculture, and fisheries. Given our economic vulnerabilities, it is imperative for us to be compensated for the loss and damage we have suffered brought by climate change. As a matter of fact, as of 2010, there is an estimated economic loss of $63 billion per year that was reported, and that this impact will rise by more than 100%, which we will have $157 billion at the end of 2030. And with continuous inaction, it would prove to be costly and expensive in our part. Thus, it is proper for us to be compensated with the loss and damage we had suffered for many years. Furthermore, although emissions often originate from private actors, the injuries sustained can be attributable to the state where the state is responsible for regulating these activities. This leads me to my second submission, that states have the obligation to protect the right to life in the context of climate change. As for our second submission, we argued that the states have the obligation to protect the right to life in the context of climate change, and this has been recognized in several human rights instruments and jurisprudence, such as in the UN Guiding Principles for Businesses and Human Rights and the Maastricht Principles. So, Your Excellencies, we had come before this court to help us bring non-compliant states accountable. Indeed, the courts had been instrumental in protecting the rights of the people, and now, although climate change has been manifesting itself in different forms and intensities, the resulting damage and loss had not been adequately covered. Now more than ever, we need this court to serve as bearers of justice for the present and the future of the EOSIS. For these reasons, we request this court to issue an advisory opinion on the obligations of states under international law in relation for the protection and preservation of forests in addressing climate change and in the provision of compensation for the climate change damage. Thank you, and may it please the court.
So my question is, what to you is the severity of this 4-degree world that you've described in your materials, what difference does it make if the Earth heats up to 4 degrees? What would that look like? You've asked this court to consider applying the criminal culpability to behavior that you described as ecocide. Why is there now a sufficient threat, a seriousness of injury that would justify criminalizing the behavior that would lead us to a 4-degree world?
Je pense que c'est important de parler de notions de crise et de danger actuellement, car malgré toutes les recommandations qu'il y a eu depuis des dizaines d'années, les pays n'ont peut-être pas pris encore la mesure de l'importance de ce qu'il se passe actuellement au niveau du changement climatique. Et en tant que jeune Française et en tant que jeune citoyenne du monde actuel, ça nous fait peur à nous parce que c'est notre avenir qui est en jeu vis-à-vis de ces situations-là. Par exemple, en Nouvelle-Aquitaine, on a été énormément touchés par tous ces changements climatiques. On peut le constater, nous, sur nos côtes atlantiques, avec le recul de la Terre, la mer qui attaque nos côtes, etc. Et on le ressent visuellement en tant que citoyen. Et c'est pour ça que ça devient un danger et une réelle crise, car maintenant, c'est effectif. Ce n'est plus juste une expectation. C'est imminent et ce sont des choses qui se passent actuellement. Les effets, nous les voyons maintenant. Et nous avons besoin de réelles mesures mises en place par nos États, par la communauté internationale et des mesures effectives, pas seulement des recommendations or not only recommendations, vraiment real measures that are imperatives. Concernant l'écocide, dans ma présentation, je l'ai amené comme un dernier recours, car on préférerait que la communauté internationale et aussi clairement notre pays soit ait pris conscience de la chose et qu'il n'ait pas besoin d'aller jusqu'à un aspect criminel pour mettre les choses en œuvre. Cependant, étant donné que toutes ces recommandations ont déjà été faites pendant des années et que maintenant les impacts sur l'environnement sont de plus en plus importants, concernant l'écocide, je pense que ça pourrait être une solution de dernier recours et une solution efficace dans la mesure où, sous la contrainte en général, les personnes, que ce soit les politiques, les citoyens, les États, réagissent mieux. Et ça pourrait être une solution de dernier recours, mais je crois encore que nous sommes assez investis et protecteurs de notre planète pour ne pas arriver à ce stade-là et pour que nous prenions conscience maintenant qu'il faut réagir tout de suite et dans l'immédiat.
And you seem to be suggesting that this duty to act needs to take place even at the level of international bodies that are applying the rule of law, such as the International Court of Justice, or I assume you're also referring to the International Criminal Court. But if it is your position, and I think you have articulated it well, why is there an extra obligation on the part of this court to act because of the injury to children that would result from massive deforestation?
We realized that there's a very high threshold and a very high legal standing for children. So they can both, they can go to court and have higher protection and be heard, but they also have stronger rights that they can claim. So this is why we can see regionally with the Urgenda Foundation case that I mentioned in my pleading, but also the Philippine case that was in the early 2000s or late 90s, if I remember correctly. And there's a growing regional courts attempt in recognizing environmental harm and how it affects children's rights, but also just generally human rights. And that's why I believe it will come to the international courts at some point in the next few years, because it cannot be avoided with this general regional consensus that is growing in jurisprudence.
The reason why we're addressing this court also is because regarding the right to fulfill human rights, one of the measures that states have to take is also to pass legislation accordingly. And since deforestation is a scientific proven cause of climate change, which is affecting all human beings, but children and vulnerable communities in particular, we think that this court should make states take those appropriate measures to protect forests in order to protect human rights at the same time.
Just a quick one. We noticed that there are many treaties, many legal frameworks to protect the environment at the national level, regional level, and then the international level. Why is it that you are bringing the issues to the International Court of Justice? Have you tried to deal with the issues at the national level?
I think sometimes when nationally courts are a bit slow in taking difficult or drastic decisions, I think it's also important to go to, for example, other regional courts or international courts and push them to legislate and judge further. Because, for example, if I, as a French citizen, go to the European Court of Human Rights, I can make France legislate new laws if the European Court of Human Rights decides that France has infringed on certain environmental rights. Then France has to work on those rights and has to promote them and ensure that they're respected. So I think there is 3 levels that, of course, must be addressed: national, regional, and international. But I don't think one excludes the other. I think they should all work together because it's a very difficult crisis. It's an urgent one, and we cannot afford to wait or lose time. And we can just, try all the different solutions we have, if that makes sense.
We are aware that Kenya ratified the Kyoto Protocol in 2005 and has shown commitment in contributing to continental and regional climate change initiatives for the benefit of the present and future generations by supporting the UNFCCC. Now, we are also aware that on May 2020, Kenya declared that through reforestation project, they will plant 1.8 billion trees by the year 2022 in order to preserve biodiversity. My question is this enough to protect the forests for the present and future generations?
Your Excellency, as a Kenyan, this question is dear to my heart as it directly affects my country. Your Excellency, my answer to this question is no, it is not enough. What this measure is doing is merely treating a symptom of a problem and not the disease itself. The disease in this case being deforestation in Kenya. Your Excellency, the main problems that cause deforestation in Kenya include land grabbing of forests such as the Mau forest, the illegal conversion of forests into land for agriculture and settlement, forest fires, and corruption that enables all the above. Your Excellency, until these issues are dealt with, planting 1.8 billion trees will only mitigate the problem and not end it entirely.
Broadly, assuming the ICJ can make such a broad principle declaration, will it really matter? Can it be given effect? And would it be better to, in fact, strengthen existing sectors? So that's the first question, and then I have another one after that. Thank you.
Thank you for your question, Your Excellency. The requests that I have made under New Zealand's submission relating to international trade are intended to aid existing international agreements in their interpretation and specifically in their prioritisation of the assessment between trade and the environment. Because we currently do have international agreements that deal with forests and trade, however, at this stage, the balance between them does lean towards prioritising trade. The declarations that we have requested from the court would help to shift states' assessment of this balance so that we recognise the fact that while international trade is crucial for the health of the international system, we do require a healthy environment for that to continue, and that the current state of international trade doesn't align with continuing to give our future generations a high quality of life. I acknowledge what you're saying about the domestic law being absolutely crucial as well, and that is very true. We hope that the submissions that we've made around the declarations will encourage states to apply that within their domestic law. Within the international trade law, there is obviously a lot of domestic law that reflects that. So therefore, if the policy that states are making at the international level do value the environment to a greater extent, this should also be reflected in the domestic law.
And the impact of climate change. So my question is, how do we reconcile traditional knowledge and of the traditional communities to help in conservation and management of diversity for the present and future generations? My second question is on the balance between sovereignty and transboundary harm. How can we strike that balance in the climate change context to protect the forests, the present and future generations? Then the next question is on what level of harm should trigger the obligation.
Certainly, traditional people and local communities are the guardians of biodiversity. And this has to be increasingly acknowledged first and foremost by our environmental policies that are currently being discussed. We know that in an international scenario, the decade for biodiversity action is coming to an end. And a starking report that has been published a couple of months ago showed that none of the 20 IC biodiversity targets have been achieved and will be achieved under the current reporting period. And traditional knowledge is a big component of biodiversity, not only biodiversity in general, but also biodiversity for food and agriculture. And in terms of our perspective that we discussed in our memorial, from an ecological approach to international environmental law, we do really understand that we are all part of nature. And this is a vision that is shared by many indigenous people in Latin America, for instance. Here, many constitutions already included rights of nature. And this is a reflection of this cosmovision. We can call it in Spanish as buen vivir of the traditional people. And so in general, it's really important that we acknowledge first this different perspective of traditional knowledge in terms of biodiversity conservation, restoration, and sustainable use. In terms of law, it is really important to acknowledge first the rights of indigenous people, especially the rights to prior informed consent, the rights. For instance, in Brazil, we have many land disputes of traditional territories, which is something that also has to be addressed by our national courts, for instance. And it's something that has to be brought to the attention of legal general scholarship, which is really important.
Do you believe the UNFCCC, if a statement such as you are seeking is made by the ICJ, can that in any way deal with private actors? Of course, I'm thinking of large emitters of greenhouse gases. Does the UNFCCC provide a mechanism in that regard?
Your Excellency, the UNFCCC being a framework convention provides a way for the greenhouse gas, provides a provision for the greenhouse gas emissions to be reduced. However, there are also other treaties like the Paris Convention that specifically deals with the current problem, Your Excellency.
Thank you very much for those responses. Could I now ask Ms. Morin, my apologies for my pronunciation, some questions. The matter that I was quite interested in that you didn't have time to deal with is really the extent to which domestic law can influence international law. And in your section on human rights, you do refer to the United Nations Human Rights Framework, which is unusual in allowing non-state actors such as civil society, of course, to make complaints, etc. But you also refer to a number of domestic law cases, which are grounded, of course, in domestic law as well as in the agenda case, the European Human Rights Framework. To what extent do you think international law is influenced or can be influenced by domestic practice?
For that question, Your Excellency, it can be observed that there has been state practice in bringing states and private actors accountable or be held liable in domestic courts. And this can be vital or crucial in influencing international law. For example, in the case of the Philippines, we have Greenpeace versus Exxon, and this is an ongoing case. We have 12,000 petitioners, Filipino petitioners, and these petitioners invoke the UN Guiding Principles on Business and Human Rights and the Maastricht Principles. These principles focus on the role of states in regulating the conduct of businesses. Particularly, these businesses primarily are mandated in not interfering with our human rights. And since the right to live in a healthy environment is a well-recognized human rights, accordingly, businesses should desist or cease from committing actions that would threaten our right to life. So in this case, Your Excellency, given the pattern that in the domestic level, citizens are now bringing the states themselves in cases where the states would fail to regulate the conduct of businesses or private actors, it is possible that it can influence international law.
So as I understand it, you're saying if enough countries or the citizens in enough countries prosecute their governments, if they're able to, that will develop sufficient customary behaviour, potentially, that may lead to a change in international law.
Not necessarily, Your Excellency. Not only the actions made by the citizens as well, but it is well recognized in several climate change related conventions that climate change is a common concern of humankind. And together with this plus state practice, it can influence international law itself in the context of climate change, more especially in strengthening or in enforcing the obligations of states and businesses, Your Excellency.
Thank you. I have no more questions, Mr. President.
My question involves the legal concepts of dualism and monism. As agent for the African Union, I'm just wondering, in preparing your submissions, did you detect a difference in the treatment of states' obligations under international law to protect forests, depending on whether the legal system is based on dualism or monism? And if there are differences, what are their differences in treatment? And what measures would you recommend to redress any differences in order to ensure that all states comply with their international obligations?
Your Excellency, yes, I did. The main differences I saw were that in a monist state, as soon as a treaty has been ratified, it forms part of the legal system of that country and can be applied directly to that country. However, in a dualist state, in order for international law to be applicable in that country, legislation must be passed to give effect to international law. Your Excellency, as you could see, this poses a challenge in dualist states as they may ratify a treaty and fail to pass legislation to give effect to the treaty. Thus, the measures I would recommend include 1, providing an economic incentive to encourage dualist states to pass legislation that would give effect to international law in the protection of forests. Your Excellency, as a representative of the African Union, I would remind the court that many African countries are still developing. Thus, economic incentives would encourage dualist African states to pass legislation in the protection of forests that is in line with international law, especially if they are in line with their development efforts. The second measure I would submit before the court is utilizing the principle of common but differentiated responsibilities. Your Excellency, many African countries still need to exploit their natural resources, such as forests, to provide for their citizens. However, this doesn't mean that they exploit all natural resources to the point of depletion. International law that is formulated should bear in mind that developing countries cannot compete at the same level as developed countries, and thus some allowances should be made in a treaty. For example, a provision could be made where developing countries can still carry out their economic activities but slowly cut down on practices that are harmful to the environment over a given period of time. This would encourage dualist states to pass legislation to this effect.
One of the requests that you've made to the court is that you're calling for action on loss and damage to help vulnerable countries and you want to look for stringent amendments to further strengthen the Warsaw International Mechanism for Loss and Damage. I assume that you believe that compensation should be paid to displaced refugees, either displaced by extreme weather or uninhabitable land, and maybe that compensation includes relocation costs as well as compensation costs for loss of their homelands. But how do you suggest there would be a fair and rational manner to allocate that responsibility amongst states?
Your Excellency, regarding the amount for the compensation, it has been recognized there is a difficulty in citing the causation, the causal link between greenhouse gas emissions and the climate change itself. So, based on several domestic jurisprudence, such as in the case of Leluya versus RWE, the domestic court took into consideration the amount or greenhouse gases by the private entity itself. So in this case, in the international level, since there has been a widely available data on the greenhouse gas based on state inventories, this can serve as a basis for the amount of the said compensation that will greatly help the small island states, Your Excellency.
You advocate for an ecosystem-based approach that recognizes the interconnected nature of the forest. If we were going to adopt that in our advisory opinion, what would be the guiding principles that we would send to states to provide some clarity to what their obligations are under this interconnected nature of the forest principle that you advocate for?
Thank you for your question, Mr. President. This would be an issue that would need to have consideration for specific ecosystems and their needs, but it would require states to acknowledge and make allowances for the health of ecosystems before undertaking major trade projects. I would say that, for example, a specific requirement may be the need to acknowledge specific species that may be disrupted. For example, with forests, you need to look at the insects and birds and ensuring that they have alternative opportunities for example, like breeding and living. If, for example, one patch of forest is being destroyed, that there are alternatives and that the restoration gives consideration for multiple species and not just the restoration of the specific plant, for example, the forest, the timber product that is being utilized.
The court will take the matter under advisement and will now stand adjourned.